Hi everyone. Today I want to go through the contract law for the breach of contract and the entitlements for damages. So I want to go through an university example on the contract law. Um, the example is that whilst so in this case we have Bruno operates a small suburban printing business from his home. He contacts a courier company as his Flexo print high volume multifunction printer has malfunctioned and needs to be transported back to its manufacturer for repair. Your contract with Bruno requires you to pick up from the printer from his home office on Wednesday and then deliver it back to him. After it has been repaired on Friday, because you're busy with other jobs, you don't pick up the printer until Friday, and because of the weekend, it isn't returned to Bruno until Tuesday of the following week. Although you didn't know this when entering into your contract with Bruno, it turns out that the Flexo print machine is Bruno's only printer. Because of the delay in its repair, Bruno loses $2,000 in profits from his regular business. He also misses out on a particular lucrative but unusual contract printing high-end restaurant menus for a global hotel chain. That contract would have generated $10,000 in profit. So in this case, you want to explain that if Bruno can claim damages from you for his two sets of lost profits according to the law of contract, explain why or why not, refer to relevant legal cases to support your analysis, and ensure that you fully explain the legal position you have taken. So to tackle this question, you first identify the issue. So the issue in this question is concerned whether Bruno is entitled to claim damages from the defendant, which is yourself, for the two sets of lost profits according to the contract law. There are 4 steps for working out whether damages can be claimed for a breach of contract, namely what is measured damages, what's the loss caused by the breach, which is causation, is the loss too remote from the breach, remoteness, and has the innocent party taken steps to avoid the loss by way of mitigation. The first step is to place the plaintiff, Bruno, in the position he would have been if the contract had been performed as expected. This is called expectation losses, similar to Robinson versus Harmon, 1848 case, where the court claimed that the other party may recover damages which would so far as possible place him in the same position he would have been had the contract been performed. In this case, as there was a breach in obligation of the contract, even though the defendant myself didn't know when entering the contract with the plaintiff that Flexo print machine was the only printer in the plaintiff's company, the plaintiff may be entitled to the loss of profits, $2,000 from the regular business, and possibly the $10,000 unusual profit from high-end restaurant if the contract had been performed as expected. However, before we conclude that the plaintiff can claim these damages, we also have to look at steps 2 and 3, which are causation and remoteness of the damages. The claim for compensation for loss of profits. In order to be awarded damages for the breach, Bruno had to establish there's a causal link between defendant, myself, breach of contract, not being able to return the repair printer by Friday as promised, and Bruno's losses, and B, the damages are not too remote from the breach. Here, the causation for both sets of profits, $2,000 from regular business and $10,000 from the high-end restaurant, unusual contract. If the contract had been performed, it's not an issue. It is clear that the for the breach of losses for both profits would not have occurred. However, in terms of the remoteness, Bruno must prove that the damages are reasonably foreseeable result of the breach. Reasonable foreseeability is usually considered under the 2 limbs of Hadley versus Baxendale. The first limb concerns losses that are reasonably foreseeable because there are losses that arise naturally or in the ordinary things or course of things. Victoria Laundry and Parsons, the loss of profits, $2,000 from regular business would come under this limb. However, the loss of $10,000 from high-end restaurant, which is an unusual contract, may not fall under the first limb, as a reasonable person may not expect a particularly lucrative contract printing high-end restaurant menu for a global hotel chain will occur during the contract period. Nevertheless, the next limb also needs to be considered for both of these losses, which is the actual notice of the particular loss that might have been suffered in the event of a breach has been given to the defendant, or in Hadley versus Baxendale case, the court statement where the fact such losses will result from breach ought reasonably have been contemplated of by the parties when the contract was formed. In both sets of loss of profits, as the defendant didn't know that the delay return of the printer will result in the business closure. Therefore, the loss of profits in both sets fail to satisfy the test of remoteness. The last step is the duty to mitigate. The plaintiff must try to reduce or mitigate the loss that he has suffered as a consequence of the breach. It is only necessary to do what is reasonable to try to reduce the losses, but if this is not done, the damages awarded to the plaintiff will be reduced. Peizu versus Saunders case describes the reasonable steps to mitigate losses. In this case, it would be unreasonable to purchase another printer in such notice, given the late delivery of the repaired printer. Therefore, it is likely Bruno cannot perform any mitigation under this situation and is able to claim full damages and not reduce damage. Overall, the measure of damages was likely to be to simply be $2,000 in the regular business should the contract be performed as promised, but the $10,000 profit is unlikely to be part of the measure. The causation test is likely to pass for both sets of lost profits, as the breach in contractual obligation is likely to pass the but-for test if the breach has occurred. However, the remoteness test is unlikely to pass due to the lack of notice given to the defendant that the cause of the breach of obligation results in loss of profits to Bruno's business, as concluded in Hadley vs. Baxendale case. Hence, in conclusion, it is likely that given the defendant had not reasonably foreseen the consequences of the printer's delay and the plaintiff had not informed him of them, the defendant is likely not to be liable for both sets of profits, similar to the case of Hadley versus Baxendale, where the court concluded the defendant was not liable for the mill's loss of profits.